Welcome to BusinessTraining.com. Today's video module is focused on Title VII of the Civil Rights Act. This is our agenda for the video topic today. Please take a moment to review the outline. The Civil Rights Act was enacted in 1964. There are 11 titles, but Title VII deals primarily with employment. Title VII prohibits the discrimination and workplace harassment by covered employers on the basis of race, color, religion, sex, or national origin, as well as discrimination based on association with another individual because of a protected trait. Extended protections are provided from amendments that also prohibit discrimination on pregnancy, genetic information, age, and sexual and discriminatory harassment of employees. Title VII is enforced by the Equal Employment Opportunity Commission, or EEOC. Title VII applies to employers of 15 or more employees who worked for 20 or more weeks in the current or preceding calendar year and covers private employers, state and local governments, and educational institutions. Title VII protects employees from discrimination in employment practices, to include hiring and firing, assignment or classification of employees, transfer, promotion, layoff, or recalls. Job advertisements, recruitment, or testing may not discriminate against job candidates. Use of company facilities, training, and apprenticeship programs must be applied to all applicable employees, and there should be no discrimination on an otherwise eligible individual. Fringe benefits, compensation, retirement plans, disability leave, and other terms and conditions of employment must not discriminate against employees on any protected trait. Title VII also allows individuals to bring private lawsuits against an employer for discriminatory actions, or the Equal Employment Opportunity Commission may file charges on behalf of employees. Individuals are required to file a complaint on discrimination with the EEOC within 180 days of learning of the discriminatory action, or the individual may lose the right to file a lawsuit. Title VII employs retaliation protection, where employees are protected from retaliation by the employer for filing charges or complaints of harassment or discrimination, or for participating or testifying in a discrimination investigation or proceeding. Employers are permitted to discriminate on the basis of a protected trait, where the trait is a bona fide occupational qualification that is reasonably necessary to the normal operation of that particular business or enterprise. This exception is an extremely narrow exception to the general prohibition on discrimination, and customer or employer preference of protected traits is not sufficient evidence to establish a bona fide occupational qualification, or BFOQ. The employer must prove three elements to establish a BFOQ. First, there is a direct relationship between the protected trait and the ability to perform the duties of the job. Second, the bona fide occupational qualification relates to the essence or central mission of the employer's business. And finally, there is no other less restrictive or reasonable alternative available. If and only if these three elements can be proven, then the normally discriminatory employment practice may be applied, which is typically in the hiring process. Bona fide occupational qualifications can be things such as hiring female actors or female roles in television or theater, or a church hiring only members of their religion to be part of their clergy. Title VII does not specifically prohibit discrimination based on citizenship. Employers may choose citizenship as a requirement for employment, so long as it is consistently upheld and is not used as a basis to favor one ethnic group over another. Employers must be careful, however, when setting U.S. citizenship as a preference or requirement for employment to avoid disparate impact or discrimination claims. As stated, it is imperative that employers maintain consistency in implementation of their policies on the subject. There are other laws and regulations that amend and apply to Title VII. Religious accommodation is a part of Title VII requiring employers to make a good effort to accommodate an employee's sincerely held religious belief without incurring an undue hardship. The Age Discrimination in Employment Act, Equal Pay Act, Americans with Disabilities Act, and Genetic Information Non-Discrimination Act also amend Title VII. If you would like more information on Title VII of the Civil Rights Act, please go to the Equal Employment Opportunity Commission website at the following link. Thank you once again for your time and attention, and this is businesstraining.com, where you can earn a master's level qualification to make more money.